Thank you, Madam Chair. Colleagues, Senate Bill 722 attempts to address two serious concerns. If rent control is an implemented remedy for the affordable housing crisis, should it only apply to a principal year-round resident? And two, since the housing supply along the coast and in wildfire zones has become even more scarce, are we to protect primary residents or all owners of homes, including second homes? Colleagues, many communities have implemented rent controls in mobile home parks that is available to full-time and part-time tenants. SB 722 attempts to correct this. There is no justifiable reason to permit a space owned by someone as a second home to be subsidized when a shortage of housing is hurting our poor and middle class. All the more so for communities that have been devastated by recent fires as individuals are trying to find places to live. Fortunately, mobile homes are affordable, but when nearly 1 in 5 are occupied occasionally by owners, these units are not available to those who really need them. So rent control enables this type of behavior. We should not be reducing the housing supply needed by struggling families because wealthy individuals can afford a second home in a nice location. All the more so when that area needs affordable housing for those who live in those areas to service full and part-time residents in the restaurants and hotels and other service industries. A homeowner's exemption, although rather de minimis, only $70, is one reasonable litmus test to find out whether this is a primary residence among many other tests. So let's address this, what I see as an abuse, and let's free up affordable housing for full-time residents. I encourage and I vote on SB 722.
Thank you very much. Witnesses in support, 2 minutes each, please.
Hi, Catherine Borg with the Western Manufactured Housing Communities Association. SB 22 and the current law are quite simple. It's supposed to be intended for people who own a single residence. Under the current law, the only way that a park owner can prove that somebody has a second residence is if they actually take a homeowner's exemption on another property. There's no other criteria that we can use to say that this person is not occupying the home as their principal residence, and because of that, it's created a great loophole in the law. So our bill intends to try to, on a go-forward basis, apply simple principles that the committee has asked us in the past to do, something that's binary. Binary to us would mean that you affirmatively have to take a homeowner's exemption on that home. According to the analysis, there is concern that some homes won't be eligible for this exemption, but we're willing to look at that and maybe exempt all of those homes because we know that those homes that aren't on the county tax rolls are small and declining as they go forward. Secondly, the bill intends to be activated on tenancies that are January 1, 2019. And we're willing to look at language and suggested language to make sure that no current resident or current residence rental agreement upon renewal would be affected by this law. This would be clarifying in that if you occupy a mobile home come January 1, 2019, the intent is that you occupy it as your principal residence. And then you would get rent control. Since there's no means testing on rent control, everybody gets it. One other thing that I'd like to point out that was in the analysis with regard to the opposition, they talked about mobile homes being unsubsidized affordable housing. Well, I think park owners who are under rent control believe that when somebody lives there under rent control, that's subsidized housing. So if we could limit this to people who it's their own residence, that makes it more fair. That makes it seems like a more fair process that you're only giving rent control to people that it's their single residence. And we believe that this bill is a good attempt to clarify the current law that kind of gets to the point that only people who live there under their principal residence should be getting rent control. Thank you.
Thank you very much. Other witnesses in support?
Happy New Year, Madam Chair, members. Frank Smith Smith on behalf of the California Mobile Home Park Owners Alliance. To reiterate a little bit, we are just looking for a way to apply this law fairly. There is no nefarious attempt to try to impose rent control in areas where it shouldn't be applied or deny someone who rightfully should be getting it to have rent control. But you know, if the mechanisms outlined in this bill have faults or are not appropriate, then we are happy to work with the committee and the opponents. But we just fundamentally don't think it's fair to allow someone who can afford a second home to benefit from rent control. That was not the intent when the original bill was passed. I mean, to put this in perspective, if this were a government program to subsidize housing, you could be sure that the government would have very strict and clear requirements on the type of documents that would need to be submitted and verified to be eligible for the rent control subsidy. And so we're just trying to find some way to make sure that this is fairly applied to people who have a second home and shouldn't have the benefit of rent control. Thank you.
Thank you. Any other witnesses in support? Any witnesses in opposition? If you'd step forward. Good afternoon.
Good afternoon. Thank you, Madam Chair. Members of the committee, my name is Bruce Stanton. I'm the corporate counsel for the Golden State Mobile Homeowners League, also known as GSMOL. I've been a practicing attorney also for many years in the area of what I would call mobile home law. Our position is that we oppose this, and the reason is because this proposed legislation really does not limit itself to what it says it is solving for. And there's really three main areas that I'll try to elaborate on. First, there's no demonstrated need for a bill in the broad scope that it's written as, that's been brought before you. Secondly, the application is simply too overbroad. And thirdly, it lacks procedural safeguards. And I think that the committee analysis really frames the question, which is whether it's worth risking the loss of rent control protections for a potentially significant number of park residents for whom the RSO protections are intended in order to take away rent control protections from some other group for whom it is not intended, which has never been adequately defined. It's alleged it's significant, but that's only anecdotal. GSMOL has never been a proponent that rent control should apply to people who own vacation homes, and that's always the thing that we hear. However, let's look at this bill. Without any empirical evidence as to how many people we're actually looking at, it's really not, and given the structure of the bill, it just goes far too broadly. First of all, limiting it to only those homes which have claimed an exemption. The key here is that shifting the burden of proof to the resident. What happens if the park owner gives a 90-day notice, the resident responds, and the park says, that's not good enough, you got to go ahead and pay the rent or else face a termination? The language in the statute as proposed is reasonably establishing. So what does a homeowner have to do to reasonably establish that this is their principal residence, and what happens again if they don't? There's no attorney's fees provision specifically that may or may not apply, depending upon whether or not you say this arises under the mobile home residency law. But it puts people in a position who may not have the resources to have to defend this by shifting the burden of proof. And that reasonably establishing phrase is very vague and ambiguous. There's another whole area that actually the proponent spoke about, or testimony spoke about, which is what about all of the homes that are on either ILT or VLF? In other words, they're not on local property tax at this point. How do they claim the exemption? How do we get the word out to them? There are estimated by HCD to be as many as 170,000 homes out of the 500,000 homes in the state of California. That's 34% of the homes that would fall into this category. What about folks who do medical subleasing under the mobile home residency law and temporarily it's not their principal residence? Can the park immediately give a 90-day notice of exemption? What about the issue of market rent, which is completely undefined? I mean, basically, just so you understand, experts can spend sometimes days arguing over what market rent is. What the bill is basically saying is the park will get to raise the rent to whatever it wants. I just feel like what the analysis talked about, which is the surgical precision that we would need to bring to bear here, hasn't been done. It's not surgically precise. And for that reason, I think that especially shifting the burden of proof away from the park owner would be potentially disastrous. It casts too wide of a net and just sweeps too many people up in that net. For that reason, we oppose.
Thank you very much. If there are any other witnesses, name and identification only, if you would. All right. I'm going to start this time, Senator Monning, and then see the mic to you. I have met with a number of mobile homeowners in the course of my career, and I'm very curious as to how many of these people you believe have second homes as mobile homes. Do you have any data that says how many people are out there who actually use a mobile home as a second home?
Some of these coastal communities, we're finding, at least what I've gotten researched, is about 18% could be second homes for those out of state or in neighboring cities.
And where does that 18% number come from?
I apologize, I don't have, I mean, I could look through my notes, but I have it.
So do you happen to know?
Anecdotally, yes. What the number that comes from is most of the people of where the rent statements are sent. And, some of them are sent out of state, out of county. We did an analysis of a community of Calistoga, about 5 or 6 parks in Calistoga, and about 18% of those were people who occupied it as second homes. Some had Nob Hill properties that the rent statements were sent to, but because of the homeowner's exemption, the park owner wasn't allowed to declare that mobile home was their second residence.
So as I understand it, there are sometimes checks that go to people at a different, at one address that are actually used at another. So the bottom line is there's really you don't have any real accurate data on this other than the speculation and, as you say, anecdotally.
Well, it is anecdotal because we can't use all the criteria that a county assessor would use, and that was the third party that we're trying to look at to use this. A county assessor, when you declare under penalty of perjury that is your primary residence and you're taking a homeowner's exemption, that means something. It means that you are intending to return to that property. You pay your property taxes there. You pay your income taxes there. You register to vote there. You register your car, your insurance, all sorts of things that make it imply that it is your principal residence. And in the instance of mobile home parks, we aren't able to use any of that criteria. We're only able to use whether you take a homeowner's exemption on another property.
And basically then what you're doing is you're trying to shift the burden to the homeowner, as I understand it. And I think at this point in time, there's really very little data to support doing this kind of extreme effort. We all agree that we are suffering from the lack of housing, and as my good friend from Orange County has pointed out, in some of our coastal areas, we've lost more houses even today as we speak. But mobile homes are not the problem, I don't believe. And I think that the lack of genuine procedural safeguards, it's basically up to the park owner to decide whether someone has complied. It's basically saying essentially that we aren't even going to allow for rent control. We're going to change those rules. I think that the lack of an accessible enforcement mechanism for addressing a violation abuses of the MRL, the mobile home residency laws, is a problem, and that should be our priority. I think this is an attempt, frankly, by the park owners to yet again get another leg up against the folks, most of whom, the overwhelming majority of whom, for this is their lifeline between a house, a place to call home, and the streets. And again, what I think we really should be doing is finding a way to perhaps level the playing field rather than to give the park owners yet more leverage to raise rents, to challenge the people who are living there, and you don't even have the data that would support that this is a serious problem. So I am deeply opposed to this measure. I think it is a problem or a solution in search of a problem, and one that adds yet another thumb on the scale of justice. Last year, we tried to pass some legislation that would give homeowners an opportunity to be able to meet the legal challenges that are being created by the park owners, because it's an uneven playing field, and we weren't able to even accomplish that with the homeowners actually willing to tax themselves in order to accomplish that. So I think this is misguided and potentially a mean-spirited approach to something, and I am strongly opposed to this measure. Senator Monti.
Thank you, Madam Chair. I also have concerns. I think the GSMOL representative articulated some of them, but to give the author the benefit of the doubt and assuming his good intentions in trying to solve at least a perceived problem, I do have a couple of questions. And again, it may be data that's not at your fingertips, but the analysis says there's 4,800 mobile home parks, manufactured housing communities in California. Do you know how many of those are protected by rent control?
I can answer about 50% of the spaces are under rent control.
Statewide?
Yes.
Of all rented spaces. And then you have, in some of these parks, somebody is a renter of somebody else owns the actual unit. In other parks, there's a lease arrangement for the land upon which the unit is placed. Is that correct?
I'm not exactly directly
There's different
trying to answer your question.
Different relationships to the land in mobile home parks.
In mobile home parks, we, as the park owners, own the land, and the residents who own the homes lease the space.
Right. And sometimes they can sublease their space or rent it.
The resident?
Yes.
The resident may sublease their space if they are allowed to under the rules of the park.
Based on the contractual arrangement with the park owner.
Yes.
The author mentioned a $70 fee. Could you tell me, I didn't catch what that pertained to.
Homeowner's exemption, when you buy a home, is optional. You apply for the homeowner's exemption, and it reduces your home value by $7,000, so 1% is $70. So if the rules are that if you have a homeowner's exemption on your principal residence, you would remove it so that you wouldn't be penalized by having a second home that's a mobile home, because you're benefiting more than $70 a year from the lower rent that's being charged on a vacation home. So it's everybody can get it. You can go to Orange County tax collector website that I built, and you can see every tax bill and who's got it.
But are you suggesting that if somebody's benefiting from the rent control, to benefit as that being their primary residence, they would have to remove the exemption they have on another residence?
Well, that's what they're doing now to get the benefit of the lower rent. So it's sort of something you can gain, because applying for the homeowner's exemption is optional.
Right. And then help me understand, for somebody who's currently living in a park as their primary residence, they have no other housing anywhere else, what would they have to do to prove to the mobile park owner that this is their principal residence?
Currently, it's the homeowner's exemption.
They have to apply for the homeowners.
Under the current law, you don't need to take an exemption on the mobile home. It is deemed to be your principal residence unless you are taking a homeowner's exemption on another property.
Then you're disqualified for doing it in the mobile home park.
No, you can take a homeowner exemption on that mobile home,
You just-
but the law created a protection for you to say that your mobile home is deemed to be your principal residence unless you're taking one elsewhere.
But who has the duty to determine that today? Is the assumption that the mobile home park resident in the park, that is their principal?
Under the current law, the mobile home is deemed to be their principal residence unless they're taking an exemption elsewhere that they have affirmatively taken on a county paper. The instances and the loophole that we're trying to close is that some people, when they buy homes in rent-controlled mobile home parks, have been advised to remove the homeowner's exemption on their conventional house so that they can be eligible for the rent control in the mobile home park.
And what was your estimate as to how many people are doing that currently?
It's an anecdotal estimate. It's somewhere between, probably 10 and 15%. It's more heavily driven in the coastal communities, in the wine country, anything that is kind of a desirable vacation place. That's where it happens.
Thank you. Thank you, Madam Chair.
Any other questions? All right, any other witnesses? Did we close with all witnesses in support and opposition? Any other questions? Senator Anderson.
When a person takes the homeowner's exemption, what is the benefit to them for doing that? Is there a break in their taxes, or how does that work? What I'm thinking in terms of is, if I were to take that exemption, are we penalizing some that haven't taken the exemption but are qualified for the exemption? If they went ahead and did it, would they get the $70 worth of value out of it down the road?
If you are a single home owner and you buy a home, you are allowed to take the $7,000 reduction to your house. That's just the homeowner's exemption, something that probably hasn't been looked at for a long time. I know there was a bill about 11 years ago that tried to raise the amount of the homeowner's exemption, because obviously now with homes, our median home price in Orange County is in the 700,000s. The $7,000 homeowner's exemption is de minimis compared to your overall property tax bill. Now the issue is, if you are owning a home and then you want to purchase a mobile home in a nice area as a second home, wine country or whatever, you should not get it. You cannot have a second homeowner's.
Right, I know I can.
One.
Right, you can only get one.
So you would put it on your principal residence. Now, if the factor is that, which is your principal residence, you can remove the homeowner's exemption so that you avoid that conflict, and you can then get a rent control place and benefit from that, which would well exceed the $7,000 exemption of $70 a year.
Right. What I was getting at is, if that is my sole property and I were to take the homeowner's exemption, because I don't have to, but if I were forced to take it, would I get any benefit from taking it? So I'm
Get the $70 reduction to your tax bill.
okay. So I'm confused. Some people have said that this is harmful to the members in the community because you're forcing them to take it. I'm curious what that harm is. I would think that everybody would want to take it if they were knowledgeable that they're going to get a $70 reduction. Is that, am I missing something?
I can't answer that because that would require speculation on my part. So, but I don't know what the percentages are, Senator Anderson, of how many people claim the homeowner's exemption, but the counties do a pretty good job when you're going through escrow to encourage you to file for it.
Well, what I'm worried about is that we have limited slots for rent control. And as I've thought through this, I can't think of any safeguards for those who are on a list who want to get into one of those communities. And I'm trying to think what the downside is for getting that $70 reduction, I don't know why anybody wouldn't want to do it unless they either didn't know that it was going to benefit them, or they were gaming the system to take advantage of a slot that a poor person should have. And so I think it's really important that we safeguard those slots for the people who are deserving of those slots. You know, 1 in 5 Californians lives at or below the poverty line. I find it disgusting that a person who can afford 2 houses would be a hog at the trough and take a slot from somebody who's trying to hang on to their first house. And so with that, I'd like to move the bill.
I don't think anyone's accusing anyone of taking a slot for a poor person. What actually your concern is that there's some undefined number of people who rent out their homes to those poor people at a rate, at a rent control rate, who otherwise shouldn't be able to because it's not their second, or it's not their primary residence for which they're taking a homeowner's exemption. So I'm not sure I follow that argument, but if you'd like to close, Senator Moorlach.
I would love to close and
Very good, you may.
maybe defend myself here a little bit.
My apologies, sir. It's not about you, believe me. It's not about you.
Under the Hill bill that we just discussed, we certainly realize how many of us own a second home. We have a primary residence in our district, and we own a home up here, whether it's a condominium or, you know, whatever. When I bought my
All of us do that, sir. Not all of us do that.
Well, I bought a home when I got up here 2 years ago, and I was surprised at how often I got letters from the city thinking I was renting it out, and I had to pay a rental fee. And I keep writing back saying, no, I'm actually living here part-time, if you don't mind. So I kind of relate to this bill in saying, okay, I live, and I take a homeowner's exemption in Costa Mesa, California. But I also live here. I don't take a homeowner's exemption here, and I would be embarrassed to take advantage of rent control because it just isn't applicable. So, Madam Chair, we have maybe 2 types of mobile home parks. We've got the parks where you know the price of a average mobile home is maybe in the $89,000 area compared to what people are paying statewide, and so we need to provide affordable housing. But we've also got some of these communities that are coastal, and we've got some like in Malibu where people are paying $4 million for their mobile home, and they are getting rent control. I can name well-known celebrities that are benefiting from rent control, and I won't do that, but I've got the names. And I'm saying there's got to be something where there's some equity and some justice. And so to say that there's little data, well, I see that as a rather weak argument, thinking that I'm trying to benefit park owners. No, they're running a business. They shouldn't be penalized when they've got someone who shows up maybe occasionally on a weekend. We've got their water bill. We've got their electricity bill. We know that they're not living here full time. And we know in their principal residence, that's where they're registered to vote. That's where their driver's license is. That's where they're getting their bills to pay for their property tax. I get all my utility bills for Sacramento to my Costa Mesa home. But we're giving these people rent control, and we're preventing legitimate business people that happen to pay income taxes to the state of California. We're preventing them from charging appropriate rent. So to say, hey, this isn't surgically precise, I find that kind of a bizarre argument that we should be able to get somewhere that says we've got to have some equity for people that, 1, need the housing, and 2, for those that don't and are abusing a rent control structure. So with that, Madam Chair, thank you for letting me vent a little, and I urge an aye vote.
Much appreciated. I don't think, though, that you, of all people, would ever say that using data is a weak argument, because as a CPA, that must not have been what you meant. But with that, thank you, Senator. Always a pleasure. There is a motion by Senator Anderson. Madam Secretary, the motion is to pass to the Senate floor. Please call the roll.
Jackson?
No.
Jackson, no. Moorlach?
Aye.
Moorlach, aye. Anderson? Aye. Anderson, aye. Hertzberg? Monning? Stern. Wojciechowski.
The vote has 2 ayes, 1 no, several abstentions. We'll place it on hold. We'll call it one more time when Senator Stern returns.